start. So for those of you who've been on these things before, I think you probably know that they're not intended to be a full-on black letter review, and particularly for this subject, there are reams of relevant pieces it could cover and spend days talking about it. What it is, a bite-sized overview, trying to get everybody thinking about some issues with buying and selling businesses, which actually we as litigators see crop up time and time again. And I might say that some of those reasons are because maybe not enough thought is necessarily given to the areas of warranties by solicitors as much as clients. So just to give you an idea, on an average SPA, and this is what I'm looking at the minute, I've covered it up so you can't see it. This is a chunky document. Pages 45 to 115 of that are the warranties. So that's a large percentage of that document. And then many times when we come to review these things, when an issue arises, I spend an awful lot of time then reviewing the individual words in the clauses and comparing those across a factual matrix of some actual events, which is the result of the claim. And what always jumps out to me about that is I get a feeling quite regularly that there hasn't necessarily been a real linking of minds between the lawyer and a client in particular as to exactly what it is the business does and how it works in real life. And good examples are, I see regularly in these clauses that there's a warranty that relating to every item or every widget that's made has been sold and it's all been within specification. And then, as you may or may not be aware, often you have a disclosure letter which you'll disclose specific issues which are disclosed against that warranty. And it might be that you list a number of items that haven't been made within specification. And between a client and a lawyer, often they feel that is satisfactory. It's often very concerning that, because just the sheer breadth of that sort of warranty, and are you really ever going to get a situation where you can actually disclose every single item, for instance, that's not being made to the actual specification? I use that as an example because it sort of always jumps out at me, something where people should sit and think, what's the reality? And this links in with the concept of knowledge. So whilst you're discussing the warranty claims and drafting them during a sale or purchase process, there's also the consideration of an individual who may be a director, shareholder, whatever. The people giving the warranties, what knowledge do they have? If you're selling a business, you're a shareholder, what knowledge do you actually have? And again, this is a point which I think lots of clients don't necessarily understand because they haven't necessarily had a lawyer who's properly engaged with it. But there's a difference between what you actually know and what you should be reasonably aware of. And there are two different ways to define knowledge, and they give very different outcomes in relation to a warranty claim. And it's not necessarily dissimilar for a buyer, because there's also a concept to deal with, which is, what does the buyer actually know? So are you going to limit a claim to something that what is set out in the disclosure, or are you going to limit a claim to or include things that buyers knew? And that's interesting as well, because again, these are quite broad concepts, and are they properly discussed with the lawyers? So if you're looking at either of these two, so understanding what warranties mean, before I believe you can actually get into dealing with any of those questions, I really think the practical point is that the people involved in a transaction need to actually understand how the business actually works in real life. So Jacob and I, for instance, we do quite a lot of work in the food and agri sector. And if you look at a food business, it's a very complex business if it's manufacturing food. And within a factory, for instance, if you're buying a business that's manufacturing, within that factory, you're going to find that there's a whole host of processes, and those go from the actual processes relating to the accounts and running the business, the sales processes, or the contracts that exist, but also within a factory, how does everything work? How do the machines work? How are the machines maintained? And when you are selling or when you are buying, there will be warranties that relate to each of these. And so as a seller, do you actually know all the work rounds? There's always a machine in a factory that for the last 10 years, nobody's had a problem with just having to use it slightly differently than the manufacturer intended because it's broken, but it does work. If you don't set that out, you're going to find you have a claim potentially. Are machines maintained properly? You might think that, well, yeah, we have an internal maintenance man and he goes around all the time. Are the records? Can you demonstrate that all of your machines are properly maintained, for instance? Do you have a full compliance with all the relevant procedures or the external legislation? And in any business, some of these things inevitably aren't always going to be perfect. And it may be really important that they are to the buyer. And so one of the issues that, again, you need to look at with this is do you as a seller simply make a warranty and then disclose against them, or do you do something which is a lot more straightforward, which is be open with potential buyers and say, well, actually there are these issues with the business, and rely on the fact that the buyer still wants it, because that's far safer. And that's one of the things that we would try and get across as litigators looking at deals, that we get involved obviously post-completion, but so often you can see how where a deal has been negotiated and these long documents where there's a lot of complicated clauses, the nuts and bolts of how the business runs are not examined in enough detail, and the effect of the warranty and the disclosure parts of this document are not run through with an eye on the buyer's perspective. What will happen when he gets this business and starts to lift the carpets? What is it that they're going to find, and how is that going to work? Because if you get it wrong, then you could end up with significant time and effort spent, not just the overall size of the claim, but the effort and the legal costs, which can be very distracting for both sides. Another thing that is interesting is from a buyer's perspective is working out in this document from the opposite side, what is it you actually need to be right in this business? So we do sometimes get clients who come to us and say, I'm just not interested in whether this or that works because I'm buying the business for this. So again, there needs to be communication with the lawyers that they don't need to waste a lot of time dealing with X point, because that's never going to be an issue for them. And that is important. And you need to also make sure that you don't lose in large disclosure exercises items hidden in the way of a disclosure letter, which actually, although you think you're getting a warranty against something, the fundamentals of that are taken away because a large chunk of an issue is disclosed and you don't read it properly. So again, just practical points to note. And so really what I'd say is invest the time pre-completion, not just in the sort of technical aspects of the document, but there's nuts and bolts of how your business works. And then another point which I've noted here to remember is after the business is sold, if you sell a company, lock, stock and barrel, often what people forget as a seller is that all of the documents and their email accounts are then gone. So you're sat facing a potential claim from a buyer and you have nothing. So they've worked on this claim for a few months after the business has been sold, and you're facing a complicated claim, but without day-to-day access to documents and emails. And that's something that is worth noting and remembering. And none of this has an easy answer, but just worth remembering that that may well be the case. And then also, thought needs to be given, and again, with a decent advice it is, but if other thresholds going to be negotiated as to what a minimum claim is, and they will vary from business to business, because some businesses by their nature will generate lots of tiny little claims. The last thing you need is for each one of those to be something that becomes an irritant. So there's work done on setting out in the warranty elements, the SP, sale and purchase agreement, minimum claim threshold, maximum claim thresholds. And then also the next point that I put is limitation clauses, which go to, how much, if there is a claim, can your opponent recover? Worth thinking. But also, are the time limits? So naturally, this is just a contract. Contractual limitation is 6 years. Do you actually, as a seller, want to be sat there waiting for 6 years for a claim to be brought by your buyer? You might want to leave the business, sell it, move on, and have some level of certainty. And so limitation clauses for time are also important to think about. And like most things, there may be a cost. If you want to limit claims to a shorter period, you might get less for your business. But they're an area that many lawyers we've found can get wrong because they don't pay enough attention to, again, what the client wants, what the client understands, and what a client really needs from these limitation clauses. Another point which Jacob is going to come on to go to in much more detail, you need to know that within any SPA, there is always going to be notice clauses, which they set out how you provide notices of a claim, for instance, or notices of any aspect that's covered in this SPA to your opposite side, so be you buyer or seller. Again, they often get forgotten. It's very easy. I've seen here where parties have assumed they can email, and yet emails aren't included. Hard to believe, but it is. And once you've signed up, you're often saddled with these clauses, and they can be surprisingly awkward for people, especially if, and Jake will come on to talk about this, things are left to the last minute. And people then suddenly think, oh my God, I've got a claim. And then you start to look at notice clauses. So I'll let Jacob do that. And then I think one of the final things I want to talk about, and again, I appreciate it's a whistle-stop talk, but is many documents these days will have dispute resolution clauses. And these are clauses designed to keep the parties out of court. Court is often slow, expensive, risky, can engage with publicity issues, etc. So sensibly, many parties, when they are looking at a sale and purchase agreement, want to find mechanisms where they can contractually agree how a problem is sorted. And lawyers often, again, put these things in. Again, what I would say, it's a very similar point to the start. As the individuals involved who know how the nuts and bolts of the business work, and also the lawyers, they need to test each of these clauses before they sign off, because we as litigators, again, see so many dispute resolution clauses which actually just don't work. They don't actually achieve what they're supposed to do. They don't reduce costs. They often make more complexity, higher costs, because what looks good in theory, when you actually run the problem through it, just doesn't work out. And without being too specific, the simple fact is there's nothing worse than people believing they have a magic clause that keeps them out of litigation, and then actually finding that when they come to look at it, it in itself creates litigation. So it's a message from my side pre-completion. It's look at the bigger picture, make sure the lawyers and the parties genuinely understand the nuts and bolts of the business that's being sold, how it works, and all the warts, unpleasantness, problems, issues, because nobody can advise if they don't know the problems. And the worst thing is they're thinking, well, I'll keep that quiet because nobody will find it. Everybody does, and then you end up with a problem. So I'm going to hand over to Jacob, who'll give you an idea of assuming that something has maybe gone wrong, or you're a buyer, what to do. So I'll pass over to Jake.
Thanks, Richard. Yeah, so firstly, some practical tips for post-completion. The key thing to do on day one is to lift the carpets of the business, and quickly. So you want to investigate the business that you've bought. You want to ask key members of staff whether they have any concerns about the way in which the business has been run. That said, don't be tempted to go off on a tangent investigating something that simply hasn't been warranted. We've dealt with cases in the past where a claimant's taken a scattergun or a kitchen sink approach to claims without giving enough consideration as to whether those issues or those losses can in fact be attributed to a specific breach of warranty or other provisions. So be prompt with investigations, but focus your attention on what the SPA actually says. Secondly, preserve evidence. So as well as documents, if there are any key staff who will be witnesses of fact, don't sack them if that can be avoided. Get notice right. If in doubt, instruct your lawyers, and I'll speak about some recent cases on the next slide which highlight the importance of getting notice right. Similarly, limitation clauses. So there are likely to be time limitations on both notice of claims and potentially issuing claims. Diarise them, and as Richard mentioned, don't court disaster by leaving it to the last minute. And on the subject of dispute resolution clauses, those may be steps which you need to comply with before you can validly pursue your claims via other means, so through the court. So make sure you comply with those steps. And that really, again, comes back to knowing the document inside out. So moving on to the next slide, I'll talk some more about some recent cases which concern notice of claims under SPAs. And they'll hopefully highlight the importance of giving notice correctly and avoiding the all too common pitfalls which can be fatal to these kinds of claim. So the first case is the case of Tioco and Aircom Jersey 4. That's a Court of Appeal case from 2018. And that's a key case which concerns what must be included and referred to in a notice of claim. So the notice clause in this SPA stated that the purchaser had to give notice setting out reasonable details of the claim, including the grounds on which it is based. And notice also had to be given as soon as reasonably practicable after the purchaser became aware of it. So sometime after completion, the buyer's solicitors wrote to the sellers alleging that it had breached tax covenants, tax warranties, and the general warranties. And that was because two subsidiary companies owed approximately 3.4 million in unpaid tax. And the buyer's solicitors sent a further letter giving a breakdown of the tax which was allegedly due some months later. And at first instance, the judge concluded that those letters didn't constitute due notification of the claim because they hadn't identified the specific warranties which the purchaser said had been breached. And so the claims were struck out. The purchaser appealed to the Court of Appeal and argued that there was no general principle that the particular warranties had to be identified. But the Court of Appeal dismissed that and ruled that the buyer's letters failed to set out reasonable details of claim, including the grounds of the claim. So, of course, every notification clause turns on its own wording, but in this case, it was held that, in general, setting out the grounds of a claim requires an explicit reference to which particular warranties or provisions have been breached. So a general reference to tax claims or warranty claims isn't good enough, even if you mention the underlying basis of those claims, because you need to identify the grounds of the claims. So the judge's order was right to strike those claims out, and the buyer lost the opportunity to pursue those claims in their entirety. And the moral of the story really is to be specific. Don't be tempted to make general assertions to try and keep your options open in due course. You need to explicitly state what claims you're bringing and which warranties or covenants you say have been breached. Moving on to the next case, that's a case of Zayo Group International Limited and Ainger. And in that case, the claimant brought claims against 7 defendants alleging breaches of management warranties given in an SPA. So in that case, there were 7 defendants, 6 of them were individuals. They had been involved in the management of the business, and the 7th was a private equity firm. And the SPA required, firstly, that any claims be notified within 18 months of the SPA, and notice could be served by delivering the notice by hand to the relevant address given within the SPA or by sending it by special delivery. And it also contained a separate clause, effectively a joint liability clause, which said that no individual defendant could be held liable unless all of the defendants had been served with notice of these claims before the deadline. So unfortunately for the claimant left it until the final date for service of notice of these claims, and the deadline was at 5 p.m. And the claimant's solicitors lined up 6 separate couriers to effect service of the notice of claims upon each of the 6 individual defendants. And in the case of the 5th defendant, the courier arrived at the address for service given within the SPA and was informed that the defendant no longer lived there and had moved to New Zealand. It's important to note that the defendant herself hadn't updated her address for service within the SPA. So the courier found that there were strong indications that the defendant didn't live at this address, and he left, taking the notice of claim with him. He actually returned later in the day after 7 p.m. and delivered the notice at the address, no doubt after an irate conversation with those instructing him. However, it was accepted by the claimant later that late service wasn't valid service as it was after the deadline. So the claimant instead sought to argue that delivery had to be understood differently where there'd been a failure to notify a change of address. And they tried to say that there was an implied term that where there wasn't a notification of an update of an address, it was valid notice to make a reasonable attempt at the original address. Perhaps unsurprisingly, the Court of Appeal disagreed. The High Court in this case disagreed and said that no term could be implied. So they decided that the clause worked perfectly well and the methods of delivery weren't dependent on the presence of the defendants at that address. So the notice of claim hadn't been served validly on the 5th defendant in accordance with the SPA by 5 p.m. on the deadline. And as a result, she had no liability to the claimant. And further, because notice hadn't been served on her, none of the other defendants had any liability due to the joint liability clause. So that case in particular serves as a salutary lesson to claimants, firstly, not to leave notice of claims to the last minute, but secondly, to ensure compliance with the strict formalities of any notice clause, including relating to service. Moving on to the next slide. I'll only briefly mention the case of Towergate and Hopkinson. That's a High Court case from 2020, but in that case, the SPA provided that notice must be given as soon as possible and in any event on or before the 7th anniversary of the SPA. And the claimant gave notice within the 7-year period. However, it had been aware of the matters which gave rise to the claim some 2 years earlier. So the court held that the wording of the notice created a dual condition precedent. So both of those conditions needed to be satisfied before a claim could have been brought. And the claimant had failed to give notice as soon as possible, and its claims failed. Again, that's another reminder, firstly, to know the requirements of the notice clause, but to act promptly if the SPA requires it. And on another view, going back to Richard's comments about pre-completion, it may serve as a warning to ensure that the notice clause itself is realistic, not unduly onerous, and can be complied with. So a buyer needs to sense check their notice clauses, make sure they're not being set up to fail. Finally, the last case I'll mention is the recent Court of Appeal judgment in Dodica and United Luck, which was handed down earlier this year. So in Dodica, the SPA required any notice of claim to give reasonable detail of the matter which gives rise to any claim, the nature of the claim, and so far as reasonably practicable, the amount claimed. So the purchaser gave written notice of an indemnity claim under the tax covenant and referred to an investigation begun in 2018 by the Slovenian tax authority. And importantly, representatives of the seller in that case already knew about that investigation. They had access to relevant documents, they had attended important meetings, and they were involved in strategy discussions. The sellers issued proceedings seeking declarations that the letter didn't give reasonable detail so that the claim was not enforceable. And at first instance, the judge agreed with them and granted summary judgment in favour of the seller. The buyer appealed, and on appeal, the court was required to consider what constituted reasonable detail in the context of this case. And the Court of Appeal held that what was reasonable depended on all the circumstances, including what was already known to the seller. So it decided that to require an explanation of details which the seller already knew was uncommercial, and what was reasonable depended on the commercial purpose of the clause and what business people in the party's position would treat as being reasonable. So business people wouldn't expect or require further detail which served no purpose, such as information which they already knew. So therefore, in the circumstances of that case, the letter had stated the matter giving rise to the claim in reasonable detail, and the claimant's appeal was therefore allowed. So that was perhaps a rare case where notice was held by the court as being valid. So in summary, I think the key takeaways from all of those cases are, firstly, most importantly, know the clause and know the SPA. So in all of those cases, the focus is on the wording of the SPA and the notice clause within the document and what that clause requires. So it's really important that parties know what they need to do in order to bring claims, and that needs to be considered both pre-completion when negotiating the SPA, but also later if and when claims do arise. Secondly, act promptly. So as soon as matters giving rise to a potential claim become known, take steps to formulate your claims and investigate and preserve evidence, but also comply with time limits. And thirdly, comply with all the formalities of a notice clause. So we've seen time and time again that getting simple formalities wrong, such as sending a document to the wrong address or failing to identify specific warranties or failing to serve in accordance with the SPA, can be fatal to what might otherwise have been good claims. I think we may have run over our allotted time. Apologies for that. I will open the floor to any questions, but considering we're fairly short on time, perhaps it would be better if you send any questions to our email addresses, which are there on the screen now. And obviously, please do feel free to connect with us on LinkedIn. You will get a feedback form, and also you will be able to sign up to our next webinar in this autumn series of contract conversations, which is on Tuesday, the 12th of October, and that'll cover jurisdiction clauses in the context of the EU potentially blocking the UK from Lugano. So I hope you'll join us then. Thank you all for attending. Have a great afternoon.